All right, welcome in everybody. We're going to give everybody else that hasn't joined us yet just about a minute to join the webinar, and then we will get started. All right, well, whenever you're ready.
All right, thanks, Dan. Well, good afternoon, everybody. Thanks for joining us today to hear about the land subdivision process. We will specifically be talking about the subdivision process in the Austin area and Central Texas. If you have any questions as we go along, feel free to ask those in the Q&A feature of your browser, or save them for the end, and we will have a chance to do a Q&A session at the conclusion of today's presentation. We will cover several topics on the land subdivision process this morning, including the legal framework and basics, the application process, the recent shot clock bill that concerns statutory review timeframes, the different types of subdivision plats, and exceptions to the requirement to subdivide or plat. As we move along, if any topics are of particular interest, feel free to let me know. So as a means of introduction, there are a few things to keep in mind. The first is that all development by private entities in the state of Texas must occur on a legal lot or platted parcel. The state itself does not have that requirement, but all private entities do. Second, all land in the state of Texas is subject to subdivision regulations, whether those regulations are governed by a city, a county, or in the case of the ETJ of a city or extraterritorial jurisdiction, both. And finally, keep in mind that the land subdivision process, or pardon me, the land development process can be broken down into three general components. The first being zoning and land use or entitlements. Second being the land subdivision process, which we are discussing today. And third and final step would be the construction permits and the actual construction of a project. So what is a subdivision? The term subdivision refers to the division of a tract of land into one or more parcels. Typically, that division is for the purpose of selling or otherwise transferring the property to another individual or entity. The completion of the land subdivision process results in the creation of a subdivision plat. A subdivision plat is a legal document which is recorded at the office of the county clerk in the county where the property is located. Here is a sample of a fairly basic one-lot subdivision plat. This is a copy of the actual document that has been recorded with the Travis County Clerk. And in a moment, I will come back to this slide to explain what the arrows are indicating. What is not a subdivision? Practitioners, lay people, developers will often use terms to describe a subdivision plat which are incorrect. You'll hear the term tax plat. A tax plat is not a subdivision plat. You'll hear the term title surveys. A title survey can be used as part of a real estate transaction, and it can show subdivision information, but a title survey itself is not a subdivision plat. And lastly, a subdivision plat is not a permit to construct anything. It is simply a legal document. So permits would come subsequent to the legal document that is the subdivision plat. So let's talk about the statutory framework. The legal framework for the land subdivision process in the state of Texas is established by our local government code. Most property in the state is located entirely within the jurisdiction of a county. For these properties, Chapter 232 of the local government code regulates the land subdivision process. Similarly, Chapter 212 contains the minimum guidelines that cities must meet as they regulate the process. And for properties located in the extraterritorial jurisdiction of a city, also known as the ETJ, an interlocal agreement between the city and affected county would govern as described by Chapter 242 of the local government code. A subdivision is technically required anytime a tract of land is divided in order to sell a portion of the property. This doesn't always happen, as we know, however. Land is often sold using a metes and bounds description. So in practice, the legal land subdivision process is typically conducted as the initial stage of a development or building project. And you can recall from the first slide that all development in the state of Texas must occur on a legal lot or platted parcel, which is why in practice, the subdivision process occurs as part of the larger development process, or is triggered as part of the larger development process. And the process itself is very statutory according to the codes. It is not open for interpretation or negotiation like the zoning or entitlement process. And with limited exceptions under state law, the subdivision process cannot regulate the specific land use or density limits of a property being subdivided. If you happen, this presentation focuses on Central Texas. If you happen to be working in the Houston area, Harris County in particular, there are exceptions in the code that allows Harris County to regulate land use through the subdivision process, but that does not exist anywhere else in the state. And the subdivision process is intended to allow for orderly development of land, specifically how the public improvements, the streets, the utilities, and the drainage infrastructure are laid out. And it's also to accurately describe the property being subdivided so that it may be located now and at any time in a later date. I mentioned that the process is not open for interpretation. In fact, under state law, there are only 4 legal requirements that must be met in order to be approved and recorded at the office of the county clerk. So let's go back real quick to our example from the beginning, right here. First, the property must be locatable with respect to the parent tract. So that's what you see. The red arrow at the top is showing the overall parent tract. Second, the property must be accurately described by metes and bounds. And so you see that with the folded arrow there pointing to both a metes and bounds table and the metes and bounds on the lines on the face of the plat. Third, it must accurately describe the lots and blocks being created. And fourth, it must be acknowledged by the owner of the property. So we meet all four of those requirements as demonstrated here on this sample plat. Now, if we go back to where we were in the presentation, that's it. Those four requirements are the minimum requirements necessary for a plat to be approved. And if a plat does meet these four requirements, it statutorily must be approved by the governing body. So keep that in mind, and I will point out that Chapter 212 does allow a city to adopt additional ordinances to regulate the process, but it does not give those cities the power to regulate the land use. It still falls short of that. The exception, of course, being the Houston area. So what happens if a developer does not comply with the legal requirements of the land subdivision process? Well, there are both criminal and civil penalties, and the city can come after you for monetary damages in order to complete the project. But perhaps the most important tool that a city can use against somebody not in compliance is to simply deny the approval of any construction permits. This includes utility companies like electric, gas, and water providers from providing services to a building or property which has not been legally subdivided. The application process for a subdivision can simply include a final plat application, but larger projects typically require both a preliminary plan and a final subdivision plat. In the City of Austin, Section 25(4) of the Code of Ordinances outlines the review requirements within their full purpose jurisdiction. And for land located in the Austin ETJ, Section 30 of the Austin Land Development Code, which also happens to be Chapter 30 of the Travis County Code, describes the review process. And these codes are both easily found online. A subdivision project can be approved administratively or by a land use commission, depending on its complexity. Within the City of Austin, a plat application which proposes fewer than 4 lots, with each lot having frontage on a public street with utility availability, does not require a preliminary plan and can also be approved administratively, meaning a public hearing is not required. So fewer than 4 lots, each lot on an existing public street with existing utility service in place in that right-of-way can be administrative without a preliminary plan. If a project does not meet these requirements, it must be approved through a public hearing process, and a preliminary plan is typically required. If this is the case, then House Bill 3167, or more specifically, the City of Austin's treatment of House Bill 3167, will affect review and application timelines, as we'll see in a few minutes here as we get into the presentation. A preliminary plan is just that. It's a preliminary planning document. It is not a legal document in the sense that it is not recorded in the county records. However, it is a legal document from the point of view that approval of a preliminary plan does represent the baseline date for any potential grandfathering rights, and it does establish a legal commitment from the utility providers in the area to service the proposed project development, both key items. Here is a sample of a preliminary plan. This particular preliminary plan is for the property surrounding and including the Martin Luther King Capital Metro Rail Station in East Austin. The preliminary plan shows the lots and blocks that will be platted from the property, including the location and layout of streets and drainage improvements. And you can see the red circles around the phases. I'll show you the corresponding final subdivision plats, which came out of this preliminary plan in a moment. So two final subdivision plats came out of this single preliminary plan. As I mentioned several times already, a final subdivision plat is a legal document. We talked about the minimum legal requirements that a plat must meet. So what else should you know about the process? One important thing to know is that once a final plat has been recorded, practically speaking, it never expires. It's valid forever unless it's vacated or otherwise changed by the property owner. There are some very limited exceptions to that statement if you dig deep into the code, but in general, the exceptions would be triggered after 50 years and with nothing having ever been built on the property. Another useful item to know when working on subdivision plat applications is that once a section of a preliminary plan has been final platted, the underlying preliminary plan section, and only the section that has been final platted, is considered null and void. The effect of this is that once platted, once a final subdivision plat is recorded, you can amend the platted lots or re-subdivide them without the need to go back and revise and seek approval for the original preliminary plan. So here is an example of a final subdivision plat, which was platted out of the preliminary plan that I showed earlier. So a couple slides back, there you go. There's the preliminary plan. And now we are platting phase one of that plan here as the Chestnut Station subdivision. And you can see on this final plat, this first page of the document, that the land has been located with respect to the original parent tract, and it states the exact dimensions of each lot and right-of-way area. And then the second and third pages here of the same final plat will demonstrate the other two statutory requirements, the meets and bounds description on the left, and an acknowledgement by the property owner on the right. And then this is the second section of the Chestnut Plaza, which was final platted as Chestnut Station Section 2, just for reference. And of course, if we went through, we could show that it meets those 4 minimum statutory requirements. So if you've made it this far, thank you. This slide, I think, would be one of the most important slides for a developer or a client of WGI's or a practitioner who happens to be listening to our webinar today. This is what you don't want to show on a final plat and why. You never want to reference zoning-related information on a final plat. And this would be things like building setback lines or density limits and the like. And the reason being that once shown on a final plat, you're stuck with them as development regulations. And there is no way to get these items taken off of the plat without vacating the affected lots, which can be a very cumbersome and difficult process. You should also avoid dedicating midlot easements with the final plat itself. Instead, dedicate those easements using a separate document and reference the document number on the final plat. Spend a couple $100, couple $1,000 dedicate mid-block, mid-lot easements, using separate instrument, separate document, show them for reference. You can go back and vacate those easements or move them around much easier than you could if they were dedicated by the plat itself. It is much easier to modify those separate easement documents than to vacate a recorded plat in order to accomplish the same goal. So memorize, study this slide. This is a very important part of the presentation today. So let's talk about what's affectionately known locally as the shot clock bill. The Texas legislature passed House Bill 3167 in early 2019. Unofficially, it's referred to as the shot clock bill. The purpose is to accelerate review timelines for land subdivision applications, implementing statutory timelines for said applications. And the bill requires a uniform 30 calendar day deadline to approve with conditions, or disapprove with reasons all subdivision applications. The bill also prohibits review agencies from adding new comments or requirements after the initial 30-day period. The requirements of House Bill 3167 apply only to subdivision applications reviewed under sections 212 or 232 of the local government code. So what that means is that it applies to subdivision plat applications, but it does not apply to site plan or site development permit applications. And specific to the city of Austin, if a change of zoning is required, the city of Austin now requires that any zoning applications be complete and approved before an application for land subdivision can be submitted. In other words, the zoning and subdivision application process, it's now a stacked or sequential process as opposed to the traditional concurrent process. Additionally, all subdivision applications, which are expected to include requests for variances from code requirements, waivers from technical criteria, or discretionary approvals of any sort, are now required to submit a project assessment application. So the effect now is that the city of Austin will require each of the following associated approvals to be complete as a prerequisite to filing an application for land subdivision. Zoning applications, approval from city legal for any non-standard documents like easements or other agreements, any utility service extension requests. So we're talking about water and wastewater there with the Austin Water Utility. And if a variance is going to be required, an environmental variance, then a positive recommendation from the City of Austin Environmental Board will be required before we can submit a final subdivision plat application. When I went through the slide about what not to show on a final subdivision plat, I mentioned that a plat vacation was the only way to get easements and other restrictions, which were dedicated by the plat itself, removed from a recorded plat, and that it could be a very difficult process. The reason for the difficulty is that all current landowners in the subdivision must sign off on a plat vacation, even if their lot is not being vacated. This is no easy task when the lot or plat you want to vacate may have also dedicated the lots of many other property owners And it's not uncommon to see unreasonable compensation requests from neighboring landowners in such situations. So here's a sample of a plat vacation document. This was a one-lot subdivision, which was vacated in its entirety. Here's a close-up view of the legal vacation documents. The highlighted section states that the plat vacation destroys the force and effect of the subdivision plat, essentially making it null and void as if it never existed in the first place. And of course, the plat vacation document is a legal document and it is recorded in the office of the county clerk. So now we get into some fun variations of final subdivision plats. The first one is a re-subdivision plat. The re-subdivision process allows the creation of multiple lots from one existing lot. All re-subdivision applications do require a public hearing. I'll say that again because it's an important point. All re-subdivision applications anywhere in the state of Texas require a public hearing prior to approval. One note of caution here for developers and clients of WGI. Often private deed restrictions or covenants and restrictions will restrict further subdivision of already platted lots and should be explored prior to considering an application. So what does that mean in simple terms? It means there could be deed restrictions associated with the property, not shown on the final plat itself, that say things like property within this subdivision may not be re-subdivided, may not be smaller than a specific size, things like that. So always review those deed restrictions or covenants and restriction documents that may be associated with the title of your property. Here is an example of a re-subdivision plat. You can see lot 1 of the original plat shown on the left has been re-subdivided into 3 lots as shown on the right. So what we did here, we took one large 24-acre lot, lot 1 of Block E, and we carved out 2 pad sites on the eastern side of the property. Another type of subdivision plat is the amending plat, and this is a useful tool for landowners and civil engineers and lawyers and related practitioners. Perhaps the most helpful thing with an amending plat is it offers the ability to move lot lines between 2 or more adjacent legal lots without a public hearing. So an amending plat is not a re-subdivision, but it does allow you to adjust lot lines and move them around. So you can slide a lot line back and forth to make one lot larger and one lot smaller, or to move around a feature like a building that was put in the incorrect location, or drainage infrastructure, or things like that. The city of Austin is sophisticated enough that they allow amending plats, and it's not usually an issue. They're very familiar with the amending plat process, but some smaller communities will balk at the idea of an amending plat because they've never heard of them or processed one. So in those cases, when you're in smaller communities or more rural areas, some level of education of their staff or their legal counsel involvement may be necessary. And I should point out that both the amending plat and the re-subdivision plat from the previous slides Neither of them can be used to remove plat notes, easements, or other restrictions. So we talked about this in terms of plat vacations and what not to show on the previous slides. The only thing that can be used to remove plat notes, easements, restrictions, building setbacks that were shown as dedicated by the plat, the only thing that can be used for that process is a plat vacation. So here are both the original final plats for two separate subdivisions. And what this is, it's going to be an amending plat example. So both plats show the location of the original lot line as indicated with the arrow. So the arrow there is on the western edge. And post amendment, the lot line has been relocated to the other side of the property. And the acreages have been updated to reflect that. So in this example, an amending plat was used to move the lot line between two adjacent lots, which were on two separate subdivision plats. Pretty cool tool to use. And if we combine the amending plat example and the re-subdivision plat example that we had in the previous slides, they do a great job of demonstrating what we're talking about, the progression, so to speak. On the left, you will see the original Miller Section 12 final subdivision plat. In the middle, you can see where it has been amended as we just went through to move the lot line to the other side of the future right-of-way. You can see demonstrated by the green arrows there. And on the right side of the slide, you can see that the amended plat of Section 12 had been re-subdivided to create those two pad site lots that are shown with the green arrows. So you can nerd out on what the name of this legally is. It is on the plat if you read it there in italics on the example on the far right side of the screen. The last document there, number 3, Section 12 re-subdivision, is now legally known as the re-subdivision plat of Lot 1 Block E of the amending plat of Lot 1 Block E of the Miller Section 12 subdivision and Lot 3 Block D of the Miller Section 3 subdivision. Quite the mouthful. So let's talk about exemptions and exceptions. There are several exemptions and exceptions from the requirements to subdivide allowed under state law. The two most common are the 5-acre exemption for cities and the 10-acre exemption for counties. Specific to the city of Austin, there are several exemptions from the requirement to subdivide. First and foremost, any parcel which has not changed configuration since it was annexed into the city is exempted from the subdivision process. The most common city of Austin exemption is the 5-acre exemption. This exemption allows tracts which are smaller than 5 acres with existing utility service and street access pass from the subdivision requirements if they have been in their current configurations since 1987 if you're in the ETJ, or since 1995 if you're in the city limits. When I first started giving this presentation, I would often be presented with questions about condominiums, and if a condominium regime was a form of subdivision. So I put this slide in. And so the condominium form of ownership does provide a means to further legally divide property ownership interest, although not in the sense of a traditional subdivision. The Texas Property Code states that land use laws may not prohibit the condominium form of ownership or impose any restrictions on a condominium which are not imposed on a physically identical, if not legally identical, project. And that would apply to your townhomes, your vertical condominiums, such as, condominium towers, or the product known as single-family detached condominiums. As we wrap up, if nothing else, I hope you can take away from this presentation that all real property in Texas is subject to subdivision regulations, and that the subdivision process is becoming increasingly complicated in the Central Texas area. If anybody has any questions, I would be happy to try to answer them now during the webinar, or you can email them to me using the contact information here in the presentation. Thank you again for joining us today. And we look forward to working with you on your next subdivision project very soon. All right, let's do some Q&A.
Awesome. Thanks a lot, Will. If you guys have any questions for Will, please go ahead and drop them in the Q&A portion up at the top of the screen, and we will we'll facilitate that and get Will to answer them for you.
Hearing none, I think that's a wrap, Dan. Thank you, everybody, for attending.
Looks like we got one real quick, Will, from Jamie, if you don't mind. It says, is there a state maximum number of lots that can be created from a single parcel before a plat is required?
State the question again, Dan.
Is there a state maximum number of lots that can be created from a single parcel before a plat is required?
If you're not eligible for one of the exemptions that I covered, and this is specific to City of Austin and Central Texas, the creation of one lot would trigger a final subdivision plat. It's a very simple plat application, one lot, in order to move forward with the development process, secure a site development permit to actually build something. So the minimum would be one, Jamie. The maximum, there is no maximum to the number of lots that can be carved out of a single parent tract under state law.
All right, it looks like that's the only one. Eduardo wants to say thank you. It's much appreciated. And thanks a lot, Will. We appreciate it.
Thank you, everybody. If you have any questions post-webinar, my contact information is here, and I'm happy to help any way I can. Thank you very much.